Welcome, everyone. I can see that there are still people trickling in, but I think we will go ahead and start on time. And those who join late can join us as they log in. So welcome. Thank you for joining our webinar today on responding to remote work ramifications. My name is Abigail Herrington. I'm a labor and employment lawyer at McInnes Cooper in our St. John, New Brunswick office. I'm joined by Alex Warshick, and I'll let Alex introduce himself briefly before we begin.
Hi, folks. As Abigail said, my name is Alex. I'm a partner in our labor and employment practice here in Halifax, Nova Scotia. I advise employers across just about all industries with a bit of a focus in the construction industry in particular. I also teach courses on occupational health and safety. So we're going to talk a little bit about safety at home as well later on today. So thanks very much for taking the time to join us.
Thank you. So our presentation today, we're going to talk a little bit about remote work in 2025. Remote work in 2025 is obviously different than remote work in 2020, which is, I think, when most people maybe envision remote work starting. Certainly remote work has existed long before that time, but that the COVID pandemic was really kind of what set it off. And our presentation today could generally be divided into two parts. And so the first half is largely going to cover some of the risks associated with mandating a return to the office. And the second half is going to cover some of the risks of remote work now that we've had the benefit of a few years to kind of see how things are going, see how the courts are treating it, see how the law has settled a little bit. And now that we've got, I guess, just a better understanding of what the risks of remote work might be. And so the goal for today, I would say, so we had the opportunity to review some of the questions that people filed in advance. There were a lot of questions about kind of what is the new, norm, what's the new standard, what is everyone else doing? And so the goal for today isn't necessarily to say, okay, should you mandate everyone to return to the office or no? We are, of course, seeing some return to office mandates. Ontario was a recent example. We've seen some of the big banks also mandating a full-time return to the office. So there definitely is a shift happening. I would say, and Alex, maybe you have a bit of a different experience. I would say for the most part, we're not seeing a ton of clients coming to us saying, we want to mandate everyone back to the office right away. I think more of what we're seeing is, okay, we at least want to, revisit our balance. Maybe lots of people are fully remote and we want to insist on at least a certain minimum number of days in the office. Some people maybe are considering going fully remote, but you're thinking about how to make that transition, gradually. But the goal, I think, for today is to help you and your respective organizations make informed decisions about what is our remote work policy, are we going to have a return to the office, and what is that structure going to look like? The advice I typically give employment clients is always that it's better to be proactive than reactive. So hopefully you can leave today with some of the tools you need to make decisions about your remote work policies, allow you to do so in a way that's proactive, that's structured, and that's intentional rather than kind of an ad hoc policy. So we're not experts on what the market is doing. We did find some statistics on what the market is saying. So this was a recent survey from 2025. Respondents were asked, which would you prefer if it were up to you? Working remotely all the time, working remotely most of the time, some office time, mostly from the office, some remote time, or work from the office all the time. And so, as you can see from the responses, 60% of people, or a little over 60% of people, still want to be at least mostly remote. 50% of people still want a hybrid arrangement. And then you have 29% of people who want to be fully remote and 20% of people who want to be fully in the office. So the demands and expectations from employees are pretty spread out. But I guess I would say that only 21% of people want to be full-time in office. So largely, I think there's still a demand for at least the flexibility, if not being a fully remote worker. So is remote work, is it a right or a privilege? That's going to be one of the big themes of our presentation today. In order to understand whether you can call remote employees back to the office or whether you could require employees to remain as remote workers, you have to have a bit of an understanding of where the right or privilege of being able to work remotely comes from. And so one of our goals for today is to help you better understand that. Obviously, aside from the legal component, there's a business component here that is a little bit, beyond what we can cover, but there is obviously a business reality that will be different for everyone. So you may be in a sector where remote work does not make very much sense, or remote work maybe only makes sense for kind of your leadership team, but not your entire staff. If you're in a market where you're having a hard time recruiting employees and you're having a hard time with recruitment and retention, maybe you have, maybe you're in a position where you can't really afford to insist on full time in the office because you have, candidates who are insisting on having that flexibility. It's going to be different for everyone. You'll also have a much better sense of your own workplace of, okay, if we make this change, are people going to leave? Will key employees leave? All of that is going to vary business to business. So you'll have to keep that in mind as you weigh the things that we tell you from a legal perspective. So generally speaking, the legal answer is that the ability to work remotely is a privilege that needs to be granted by the employer unless you can identify a specific legal right somewhere. And so there are cases where employees may have what we would consider a legal right to work remotely. They can come from two sources. Either it can come from legislation, which we'll talk about, or it may come from their employment contracts. This is our map of where the legal right for remote work might come from. As I said, it can come from legislation or contract. If it comes from contracts, it will be a little different depending on whether you have a non-unionized workforce or a unionized workforce. In terms of legislation, there is no legislation that says you must provide employees the right to work from home. It does not, there's no law out there that says that, but it arises generally from two different types of legislation, depending on your province. It will typically arise from either workers' compensation legislation or the Human Rights Act. And the way that it arises is similar in both cases, which is that an employee may have a right to work remotely if they're entitled to an accommodation, and that's kind of the only available accommodation. So both workers' compensation legislation and human rights legislation impose on employers a duty to accommodate up to the point of undue hardship. That could include the option of allowing an employee to work remotely. The important thing to keep in mind, though, is that the duty to accommodate is to provide reasonable accommodations, and it only is up to the point of undue hardship. The employee does not have a freestanding right to pick their own accommodation. So the mere fact that you might be approached by an employee who says, I have this condition, I have childcare obligations, I want to work from home, that's not the be all end all. That's the start of a conversation that you're obligated to have under different pieces of legislation. But it's not an absolute right of the employee to choose their accommodation. So there's an entire process there that may result in the right to work from home. But it's not as simple as an employee saying, I want to work from home because of this reason, and therefore you have to provide it.
I think that's a really important point, and maybe one of the key takeaways from today's session is we got lots of questions in advance of the webinar about sort of requests to work from home on the basis of an accommodation, some protected ground, so childcare or maybe a medical issue or disability. Very important, I think, is the takeaway that work from home is not the default accommodation. The employee says, I have X reason I need to work from home. that's not the starting point. The option or the accommodation of working from home, it might be the only one that makes any sense in the context. But it's not necessarily the starting point. If it's a medical condition, you need to understand their medical limitations first, and then with that in mind, determine what makes sense. It may be that a relatively cheap option is a standing desk in the office, which replaces the need to work from home. Same with childcare, needing to understand exactly what the time commitments are, and so forth. So, I have X, or there's this reason why, and I need to work from home. That's not the starting point. Just on the point of questions, we did receive a lot of questions in advance of the webinar, so we do have those. We're going to try to address those as we go through the topics in today's webinar. But there is also a Q&A option in the Teams window. So if you do have questions arise as they come up, please feel free to put your question in, and we'll either answer it as we go if it's on topic, or we'll deal with them at the end. So again, if you have questions, please feel free to type them out in the Q&A box.
Thanks, Alex. And I would say that the most common ones, and I don't know if your experience has been different, but the most common ones that I've seen are medical accommodations and a lot of childcare and family status obligations. And my sense has been that a lot of employers feel that, particularly with the family status or childcare obligation, that remote work is kind of the only option that's available to offer. But that's not necessarily the case, and we do have the right to ask some questions and engage in more of a dialogue about what options are available. It's not as simple as someone needs to leave at a certain time to pick up a child from daycare, and so they're entitled to work from home all day, 5 days a week. So it's definitely more nuanced than that.
That's another really good point while we're here, is that you do have the right as the employer to ask questions when you're facing a request for an accommodation. You have the right as the employer to get as much information as you need to have a factual foundation on which to give that accommodation. So, that's why when somebody's looking for an accommodation for a medical reason, you have a right to know, to the extent necessary, what their limitations are. I think the same is true of someone's childcare responsibilities. I think the issue that we're seeing, and some of our clients are seeing, is that there's these very on the line requests about working from home, where it's not quite clear that it's really tied to any particular protected ground of discrimination. It's not family status, it's not necessarily medical. It's might be couched in that kind of language, but it's more of a preference. And so it's how do you sort through those? Well, you sort through those by doing the legwork of the accommodation process, and that's a two-way street, right? You have the right to ask for information from the employee and then evaluate what makes sense in the context as an accommodation, and that might not be work from home as the first stop in that process. It might be something else, leaving early and logging on at night, if it's about specific times during the day, or coming in a little bit later. Or maybe again it's if it's an ergonomic issue with standing desks, like there are other steps to explore before necessarily the blanket, okay, you have to work from home.
Yeah, completely agree with all of those comments. So those are sort of the key sources of where a right to work from home might arise from legislation. The other place that a right to work from home might arise is in contract. And so this can be in two forms. First, it could be an express term of an employee's contract. And second, it could be an implied term. So we're going to talk about that a little bit more, but it may be the case that if you've hired employees during the pandemic, they may have a right to work from home because you may have put in their contract that they are to work from home. So it will be important to remember to go back to the contracts that you have and see what you might have already agreed to. And then there's also cases where the law might imply a right to work from home as part of the employment agreement, totally separate and apart from any rights that may arise under legislation.
Yeah, that's the tricky part here, is that you probably have employees that signed employment agreements, if they've been with you, let's say for 6, 7, 8 years or more, they may have signed employment agreements that have a specific location of work clause. It might say, you're going to work from our office in Bedford, Nova Scotia, or, it might be, specific as to where they're going to work. And as a pandemic response, you'll send everybody home. Everyone started working from home, and now you're looking to recall them to the office. Whether full time or on a part-time basis. There you've got something in the contract that I think you can rely on as the employer. That it was always intended that you were going to be working from the office. There was this extraordinary event, and now we are recalling you to the office on X basis, whether it's full-time or part-time, as per your employment agreement. Where it gets a little bit tricky and where timing really comes into play is that somebody hired during the pandemic or after the pandemic might only know that remote work arrangement, right? So, potentially it's in their contract. So their location of work clause, if you have one, says, this is a remote work position. It's expected you'll work from your home office and may be required to travel from time to time. That's probably a common one that's out there. Or maybe the contract is silent. This is where it gets, more difficult. The contract is silent on the location of the work. And the question then becomes, what was the expectation at the time of hiring? And if you're hiring somebody in a remote work environment during the pandemic or after the pandemic, I think that there's probably an argument that it's an implied term. Everybody understood that they were going to be working from home when they were hired. And it's whether or not you've got something, especially something in writing that suggests otherwise. Was there a covering letter or email to your offer to them saying, this is a work from home position for now, but we're going to go back to the office? Was there any of that communication at the time that the work from home arrangement wasn't permanent? If not, we might start moving into the realm of having a contractual right to work from home, and whether or not that changes, based on sort of the employer unilaterally deciding folks are going to work in office, that could lead potentially to constructive dismissal, which Abigail is going to talk about.
All right, so many of you may have heard of constructive dismissal and remote work cases. It seems to be kind of the magic words that are thrown out by employees who are asked to return to the office, who don't want to return to the office. In my experience, usually kind of one or two things arises. Suddenly the return to the office is resisted on the basis that they need to continue to work from home as accommodation, whether it's child care or medical issue or whatever. Suddenly, the implied understanding that they would work remotely forever is challenged on the basis of an accommodation, or people throw out the term, this is a constructive dismissal. So constructive dismissal is a real risk. Constructive dismissal is a legal concept that essentially prohibits an employer from unilaterally changing a fundamental term or condition of employment. So obviously all of your employees are hired to work for you under employment contracts, whether they're written employment contracts, oral employment contracts. Everyone has a contract to provide work to their employer in exchange for a certain amount of pay and maybe some other terms. The employer is bound by that contract. And so the law says that the employer can't then turn around and make unilateral changes to fundamental terms or conditions of employment. And so employees will say, well, you can't, remote work and the ability to work from home or to work flexibly is a fundamental term or condition of my employment. You can't change it. And so that is true to an extent. There is a constructive dismissal risk that you need to be mindful of, but there's also a solution to that problem. So one option is to provide advance notice of the change. So the risk that arises with constructive dismissal is that you're at law considered to have terminated an employee by changing their employment contract. Of course, an employer is entitled to terminate an employee's contract of employment as long as they provide reasonable notice of doing so. So the solution to constructive dismissal claims, for the most part, is to provide notice to employees of the change. We had some questions come in advance of what's the right amount of notice. The answer that I'm going to give is the very annoying answer of it depends. There's no clear-cut answer for each case. The idea, though, behind it is that you need to give the same amount of notice of a change that could be considered constructive dismissal that you would need to give if you were just outright terminating the employee's employment. So that will depend on a number of factors. It will depend on if your employees are unionized. It might depend on the terms of your collective agreement. If they're non-unionized, you might have terms in your employment contract that govern the amount of notice that you need to give. Or you may be bound to give reasonable notice of the change at common law, which can vary significantly, even from employee to employee within your same workplace. So if you have an employee who's been working with you for 10 years, you would owe that employee typically at common law more notice than you would owe a brand new employee who's been working with you for a year. So I think I'm always reluctant to give general advice, but a starting point would be the more notice you can give, probably the safer that you are. And depending on the size of your workforce and how many employees you have, and whether you're trying to recall everyone at the same time or you're slowly phasing it in, you would want to make sure that if you're calling everyone back at the same time, you give enough notice that the employee who has the greatest entitlement also gets the right amount of notice, if that makes sense. I don't know, Alex, if you have anything else to add on that topic.
Yeah. I mean, I think it's really a calculus, right? Like when you're making a significant change affecting, let's say, the entire group of employees. So we're going to recall everybody back to the office. When you're looking at your 10-year employee, their common law entitlement, if you were to terminate their employment, which, a constructive dismissal is a change that's effectively treated like a termination. Let's say you would owe them, for the sake of conversation, 10 months of notice. You might have other employees who've only been there for a year or two. They might be entitled to 1 or 2 months of notice at common law for termination. And so what you're wanting to do is pick the right amount of notice that covers off as much liability to the employees as possible, because you're going to have some at the long end of service, some at the shorter end of service, and a range of potential entitlements in the event somebody were to make a claim that they had been dismissed as a result of this change. So, you're picking a number that's covering off as many employees as possible and their entitlement, or the bulk of their entitlement. So there is really a bit of a calculation considering sort of all of your employees who are going to be affected by the change and trying to pick the right number. Generally speaking, we're not talking in weeks, we're going to be talking in months here, that you're giving employees enough time to make the adjustments that they need to make to come into the office, and trying to limit your liability for potential constructive dismissal claims. One of the other things is that the other major defense to a constructive dismissal claim is agreement or acquiescence. So those are two slightly different things. So agreement is the employee agrees to come back to the office. If you're getting employees to sign off on the return to work, that might be a defense to a constructive dismissal claim. My only concern there would be whether or not the employee is actually receiving anything of value for that agreement, especially if their written employment contract already says that they're working from home, or they were hired during the work from home era, we'll call it. So, 2019 on, and their expectation is that they're going to be working from home. So you might not be able to rely on agreement if you haven't given the employee something in exchange for that agreement. Offer acceptance consideration, that's contracts 101. Acquiescence is different, which is where if the employee goes along with the change for long enough, they lose the legal right to claim to have been dismissed. So if your employee has been back in the office now full-time for 6 months, they didn't protest the change at the time that it occurred, they can't rightfully go and claim to have been dismissed. That very likely that claim will fail, because they went along with the change for so long without protest that they've acquiesced to the amendment of their employment terms.
Yeah, all very good points. And it just occurred to me as you were talking that one of the other, I think, advantages from a legal perspective of giving the most notice that you can of an expectation to return to work is it may help protect you against some of the human rights complaints that you might face. So, for example, if you have someone who's been working remotely for 5, 6 years, they've built their childcare arrangements around having that flexibility. And you say, well, we need you back in the office in 4 weeks. I mean, we all have general understanding of what the daycare system is like. You can't necessarily find a spot within 4 weeks. And so people need time to kind of make adjustment to their lives. And so to the extent I think you can give more notice and be a bit more fair in that sense, you will protect yourself, not just on the constructive dismissal front, but also on the human rights and the accommodation piece that we were talking about earlier.
Yeah, I mean, I think if there's another theme to today's session, it's, think about what is practical. Obviously you're here on this webinar to get our legal advice and information, but I think it's always got to be guided by what's practical. So if you give employees a significant amount of notice of the return to office, 6 months, 8 months, 10 months, a year, those employees that weren't going to go along with the return to office, they'll find another job in that time, or they'll be looking for another job, which then, if they quit on their own volition, extinguishes your legal liability to them for things like termination notice. So, what is practical often impacts the legal risk and the legal liability. And I think as we get into the Q&A at the end, like practicality is key when you're thinking about requiring return to work. What are you gaining out of it? What are you losing out of it? Does it make sense for every position? What's it going to do to morale? Is it a cost saving measure? Whatever it might be, I think the practical has to really weigh in here when you're making these decisions.
And so, speaking of practical considerations, so one of the issues that had kind of been a bit of a live issue from a legal perspective was the practicality of, well, if I offer someone to return to work in their same position at the same rate of pay, it's just in the office as opposed to remote, have they failed to mitigate their damages? And so there's a concept at law that says when an employee is dismissed, yes, they're entitled to reasonable notice, but they have a corresponding duty to look for new work in an effort to mitigate their losses. And if they either don't make sufficient efforts to find new work, or they decline a reasonable offer of employment, then they can be, their damages can be reduced based on their failure to do that. And so one of the kind of open questions was, well, if I offer an employee the ability to return to the office, they haven't lost any pay and it's their own fault because they declined the position. And we've had a few cases come down just this year in 2025 that have kind of at least started to answer that question. And the answer for the most part has been no. So the courts have said you can't avoid liability by basically forcing the employee to accept the very change that caused the constructive dismissal. So to Alex's point on a practical component, you have to keep in mind that, the initial idea that maybe the practicality was it didn't really matter because it would be the employee's own fault for not accepting the new job isn't going to pan out. It seems from the cases we've seen so far, there may be cases that come to a different view, but so far that hasn't been the case. So again, this just feeds back to the practicality of if you give a bit more notice, you can help avoid that by basically, rather than taking the harder line approach of saying, well, you should have mitigated your damages and you didn't, so it's not our problem. You kind of do the opposite and you help the employee mitigate their damages by giving them lots of time to decide whether it's going to work for them and hopefully look for new job opportunities if the full-time in office isn't going to work for them.
Oh yeah, sure. I'll hop in on this one. So obviously we've talked about contractual rights in the non-union context. So what's in the employee's written employment contract, or if they don't have a written employment contract, what's implied into their oral contract. The other side of the sort of contractual right or potential contractual rights is in the unionized context, where you have a collective agreement that governs your relationship with the union and the employees. This is pretty new ground, I would say, just because, when you think about the types of industries and workplaces that are unionized, especially here in Canada and particularly here in Nova Scotia, it's a lot of work that's done in person. You picture the plant, you picture the hospital, the school, it's in-person work. So it's not necessarily something that had been top of mind at bargaining tables, to date. Now I think it's becoming more of an issue. There was a Bloomberg study or poll rather a couple of years ago that I think only something like 4% of collective agreements had anything in them about work from home. And it's only sort of recent stories and recent trends that we're seeing unions trying to bargain for the right to work from home. Where you might get caught, though, because it's more than likely that your collective agreement right now has nothing in it that says that there's a right to work from home, or that a particular classification or job, its duties are to be performed from home. Probably, unless you've very, very recently renegotiated a new agreement, there's probably not language to that extent. What there could be, though, is language around the status quo, so maintaining existing practices. And it would be, a question about whether or not working from home was one of those existing practices that are supposed to be crystallized under that type of clause. Again, I suspect that if the existing practices clause has been in for a while, that working from home wasn't one of those practices when that first went into the agreement. But that's going to look at sort of tracing the history of the agreement, the history of that clause, and the history of the practice itself. One of the other ways that maybe working from home in the unionized context could become a right is through estoppel. So if you've allowed it as the employer for long enough and it's become an expectation of employees, then if you try to exercise your management rights and bringing them back to the office and the union grieves it, there may be some argument from the union that you're stopped from bringing them back because you've created this practice and you've allowed this work from home. I think that would most likely only come up or would have the most strength as an argument if you had requested the return to work but not enforced it. So if you told employees, the expectation is you're going to be I say return to work, sorry, return to office. You're going to be back in office or back in the workplace physically, and they refused, or there wasn't enforcement of that, and sort of if you had failed to follow up as the employer on the request to return to the office, then and you let that go for long enough, it's kind of the reverse of that acquiescence issue that we're talking about on constructive dismissal. If you, as the employer, have acquiesced to them working from home despite your request that they come back or your command that they come back, then in the unionized context there may be that estoppel issue, which is that the union can argue that you've acquiesced to this practice and it's now more or less enshrined.
So what do you do about all the risks that we've just flagged for you? So we've talked about some of the strategies about giving notice, stuff like that. The other big piece is use employment contracts, use workplace policies to set clear expectations for employees and position yourself to enforce those policies if you need to. So I would imagine that if some of you go back and look at your employment contracts for employees that you hired at the beginning of the pandemic, you may be disappointed in that they may be silent on some of the things that you're going to think about leaving here today. I mean, that makes sense. We were all very preoccupied with a number of different things at the time. But moving forward, you have the opportunity with each of your new hires to set new expectations within the employment contracts. And you also have an opportunity to sit down, decide as an organization what you're going to do, what your policies are going to be. And to the extent that you can document those in employment agreements and workplace policies, that's going to help protect your interests against complaints from employees. So in terms of employment contracts, employment contracts are very important. We can't urge people enough the importance of using written employment contracts when you're hiring employees. And these are some of the examples of why. So For example, when you're hiring an employee, I think you would want to consider where's their place of work going to be? Is it going to be an office? Is it going to be remote work? That should be specified ideally in the employment contract. So we don't have to fall into this murky gray area of, is there an implied right? Is there not an implied right? Has there been acquiescence? Any of those more complicated questions, just spell out the expectation in the employment contract itself. Set out a reservation of your right to make changes to the remote work policy, so that if, as you know, as things change and adapt, you need to require more in-office time or maybe less, reserve that right for yourself as an employer to make those changes. Remote workplace requirements. So you have to think about, like, what does remote work mean? Does remote work mean working from a home office? Does it mean that an employee can take their laptop and work from a coffee shop in Europe? Does it mean that they can work from their hotel room when they're traveling around? What does remote work actually mean? I was personally involved in a case where there was a dispute about this very thing on whether remote work meant remote work from anywhere or remote work from home. And ideally, you would have specified that in the employment contract. So just be as clear as you can. And then one of the things we're going to get into later is remote workplace safety. So requirements for a home office, if you're going to allow an employee to use a home office, probably setting some expectations for the safety of that home office. Setting expectations for data security and privacy. We're going to get into that a little bit later as well. So spelling out as much as you can your expectations in your employment contract at the outset of the relationship can position you to enforce those expectations later, rather than getting sucked into an argument with the employee about, well, this is what I thought it was, and you say this is what I thought it was, and then nobody can really figure out what the expectation was.
And just on sort of the contractual terms that you might use, when you're specifying the work location in the employee's written employment contract, you might say that this is a work from home position, but maybe best practice would be to leave yourself some wiggle room as the employer, that the work location could be changed by the employer, with notice, and you agree that this is not a constructive dismissal. Whether or not that would stand up, I have always questioned if you have the employee agree that that a fundamental change to their employment in advance of that change happening would not be a constructive dismissal. I have some question about whether or not it's enforceable, but you would want, I still think it's good practice to try to protect yourself and leave yourself, as much ground to say that you have the right to require the employee to change their work location.
I agree. And I think it also sets the expectation with the employee that it may be subject to change. And so you may reduce the risk that an employee complains about it because they feel like, well, I did sign up for this. I always knew it could be changed. And they don't feel as caught off guard because it was set out in advance. So some best practices for kind of managing policies in your workplace around these issues. First, as we talked about before, you have to distinguish between work from home requests that are based on legal rights versus discretion. So you have to keep in mind and keep track as an employer from an HR perspective, who's working from home because it's an accommodation and who's working from home because it's a discretion that's been granted. Obviously, you need to treat the people who are working from home as an accommodation differently than those who are not. Set clear remote work criteria and expectations. We've talked about that. I think that's both in the employment contract and then a more detailed remote work policy ideally would be the goal. Make sure that you administer policies in a non-discriminatory and fair manner. So you want to make sure that you don't inadvertently bump into a human rights issue, for example, if the way that you're administering a policy has a discriminatory impact. So, for example, there have been some studies suggesting that female employees will disproportionately self-select for a flexible work from home arrangement, often because of family caregiving responsibilities. If you have policies or benefits in the workplace that are based on, a certain amount of attendance or if you end up favoring employees who are in the office for certain benefits or promotions, you can find yourself in a bit of hot water in that the way you're administering your program is discriminatory. So just try to keep those things in mind. And then aside from just the purely legal perspective, if you're going to be allowing certain employees the ability to work from home and not others, I would suggest that practically that is a bit of a breeding ground for bad morale in the office, complaints about favoritism. And once people feel scorned in the workplace, they can start making complaints and allegations that are difficult to defend. So just keep in mind, if you're not going to have the same policy for everyone, or if there are going to be differences in the workplace, just be really mindful and really careful about how you're making or allowing those differences. And then at the end of the day, you have to be prepared to manage these issues. I mean, no one, you're going to have a workplace policy. Your employees might read it when they're hired. They might never read it again. They might forget it. You can't avoid the need to manage, but I think at least having the expectations set out in writing is helpful. And training for managers and supervisors to ensure that they're all on the same page for how remote work is going to be allowed, I think is really important. I think one of the biggest things that I see is differences between different managers for the same employers, or different offices having, different practices. One supervisor allows more remote work than others. Whether the complaints are founded or not, those kinds of differences create, like I said, just a breeding ground in our experience for people to start making complaints. So try to ensure that you have your entire management and supervisory team aligned and on the same page on how those issues are going to be managed. Okay, so that kind of wraps up our first half of the session, which is some of the risks of requiring a return to the office. Now we're going to switch to some of the key risks of having remote workers. Now that we've had the benefit of a few years to kind of see what those are. And so I'm going to turn it over to Alex to start this part of the presentation.
Yeah, so we're going to talk about three, I think, specific risks to employing people remotely. So the first one, and I'll call this another one of our sort of key takeaways, is that if you're hiring somebody in a different province than your sort of usual operation, you're taking on the risk of liability in that province. So classic example is we've got sort of the employer that's based outside of Nova Scotia. That's where its head office is. That's where it's the bulk of its employees are, but it has this one position that can be done fully remotely, and so it decides to hire somebody here in Nova Scotia. Well, by hiring somebody here in Nova Scotia, that employer has taken on the risk of being sued here in Nova Scotia. They've taken on the risk of having a complaint that they're not complying with labor standards here in Nova Scotia. They've taken on the risk that they could be inspected and found non-compliant by an occupational health and safety officer here in Nova Scotia. They've taken on the risk that they might be deducting the inappropriate amount of tax for the employee. So I think that one of the things that you have to keep in mind and again, key takeaway from today's session is when you're hiring an employee in a new jurisdiction to you as the employer, you are inheriting the risk of being sued there and of being found non-compliant with the legislation in that jurisdiction. Doesn't mean don't do it, but it means that you've got to put some more thought into it other than this is our best candidate. They're in this province. We're going to hire them there. There becomes a bunch of things that you're not necessarily thinking about when you find that candidate. Shouldn't stop you from hiring them. But you've got to think about sort of the risk that you're taking on and then plan accordingly. Another one that comes to mind is workers' compensation. So not every province works like Nova Scotia, where there's a particular threshold number of employees, or where workers' compensation is only required in a certain industry. Every province has a different sort of requirement for when you need workers' compensation, and in some you may trigger the requirement to be insured under that province's workers' compensation scheme just by hiring a remote employee in that province. So you've got workers' compensation, you've got tax considerations, you've got occupational health and safety considerations, and then you also have the risk of liability for employment claims. So generally speaking, as you can gather from what I've just said, I think the view is crystallizing in employment law that the employee is going to be subject to the laws where they're working from home. So if they're working from home in Ontario, or they're working from home in Quebec, and even though you're based here in Nova Scotia, expect that Ontario laws are going to apply to that employee, especially when we're talking about sort of the black and white statutory law of things like workers' compensation, occupational health and safety, and employment standards. Where it gets a little bit tricky is on, let's say, civil claims. Generally speaking, I think that the courts of other provinces are going to be reticent to say that an employee would have to sue their employer in another province, even though they worked and performed all of their duties in the province where they live. But one of the ways that you might protect yourself as an employer is by including in your employment contract a term that any civil claims arising out of this employment relationship have to be pursued in the courts of Nova Scotia. So you might have an employee who's working in Alberta, but in your contract, you've agreed with that employee that if they want to sue you, so careful, it's not an employment standards complaint, it's not a statutory claim, it's a civil claim. If they want to sue you for something like wrongful dismissal, they've got to do it here in Nova Scotia. The issue with that is that there's increasing case law on what's called sort of unfair or unconscionable clauses in contracts. The classic example came out from the Supreme Court a few years ago, and it was the clause in Uber drivers' contracts that required them to pursue any claims against Uber in the Netherlands. So the Supreme Court of Canada said that that was an unconscionable or unfair bargain and wouldn't enforce it. I think that may come into play if you're requiring a remote employee to sue you here in Nova Scotia, for example, depending on the level of the position and the sophistication. I think it's one thing if it's a very highly paid executive employee who had legal advice when they signed the contract, versus a front level employee who has fewer resources to pursue a lawsuit in another province where they don't reside. So, takeaway is that when you're hiring employees in other jurisdictions, you're assuming the legal risk of employing them in that jurisdiction. So in terms of best practices, one of them we mentioned is, depending on the level of the position, maybe including a clause that lawsuits need to be pursued here in Nova Scotia. It's called a forum clause. Making sure that you keep tabs on your employees so you know where they're working from, because that will affect things like taxation. It will affect things like workers' compensation registration. One of the things that we saw during the pandemic was that we had clients who had employees who had moved all over the place during COVID-19, and they were unaware that the employee had switched provinces or even switched countries. So, making sure that your employees are regularly updating their contact information, that if they're going to move, jurisdictions, that they're getting approval to do so. That's another good practice. I think also, when you go and you hire that employee in a new to you jurisdiction, we'll say, that you're reaching out to legal counsel to find out if you're taking on any obligations that you hadn't considered. One of the ones that immediately comes to mind is that workers' compensation registration. Depending on the nature of your industry, depending on the requirements in that province, you may unwittingly not have registered for workers' comp, and you might already have an employee in that province and not be registered for workers' comp when you should have been. And so the risk there is that while a relatively low risk of injury, I think in general in the home workplace, there is the risk that the employee gets injured, whether it's in their home or whether it's driving for a work purpose, and then you're not covered. And so not only are you now subject to the risk of that claim and the cost of that claim, but also fines and penalties for not having registered.
One of the other things, Alex, if I can just jump in quickly, is I would say one of the biggest mistakes or issues I guess I see is employers who have hired someone using their standard form contract. They have an employment contract that says, upon termination of their employment, we'll provide you with the minimums required under the Employment Standards Act. But the Employment Standards Act they're referring to is the Employment Standards Act of Ontario. And so all of a sudden, for an employee in New Brunswick or Nova Scotia or a different province, you're letting an employee go thinking that, you have certainty on their entitlements on termination, usually somewhere in the range of, 2 to 4, maybe 8 weeks max kind of thing. And all of a sudden your termination clause is invalid because it doesn't comply with the standards of that particular province. And you're exposed to payment of reasonable notice damages, which can be, 24 months plus in really serious cases. So it's really important I would suggest if you're hiring employees in different provinces to make sure you have different contracts in place for each province and have them reviewed by someone who can tell you whether they comply or not, because you could end up with significantly more liability to an employee when you let them go than you anticipated.
Yeah, I would just add to that the number of times we see dropping the ball on the 1 yard line, essentially. You've gone to legal counsel, you've had them develop a template that, to the best of their ability is going to be compliant with the legislation, limited employees' termination entitlements. And then in filling out that template, you accidentally don't change the province of employment or the reference to the correct employment standards legislation. You then send that contract to the candidate or to the employee, they sign off on it, and many years later you go to rely on it, but it's referring to the wrong laws. And there is a case here in Nova Scotia that says that if the employment contract's termination provision refers to the wrong laws, it's unclear what it meant, and so it's not enforceable. So the template is great, but for the sake of the 5 minutes or the 10 minutes that it would take your legal counsel to have a final set of eyes on it before you send it to the candidate, that I highly, highly, highly recommend that. It's not that much work for your counsel. You can fill out the template yourself, but quickly flip it to whoever your counsel may be to have a final set of eyes on it, making sure that nothing in filling out that template has been misplaced, because it can pay dividends later on. Just switching to occupational health and safety, one of our other specific risks. So in some provinces, OHS legislation has caught up to the work from home era. So for example, in Ontario and in BC, it's very clear that occupational health and safety legislation applies in the home workplace. BC has, specific provisions for the home workplace. Ontario has amended their act to be very clear that it applies in the home workplace. I would say here in Nova Scotia, you should assume that the Occupational Health and Safety Act applies in the home workplace. This is because the definition of workplace is broad enough to capture the home, whereas in New Brunswick, it's very explicitly excluded in their OHS legislation. So again, this is a reason to understand the jurisdiction that you're employing people in. In terms of how you actually action your occupational health and safety obligations, obviously, most of this legislation is not written with the remote work era in mind. You look at the Occupational Health and Safety Act here in Nova Scotia, it doesn't have any explicit consideration of the home workplace. So it's really, we start from first principles. What's your first principle as an employer? It's take every reasonable precaution to ensure health and safety in the workplace. So every reasonable precaution, how do we build out from that in the home workplace? And I think some of that should be informed by what you would do in the physical workplace. So one of your requirements in the physical workplace is, for example, to keep a copy of the act, the regulations, your Occupational Health and Safety Committee meeting minutes, your policy, etc., in an accessible place in the office. So often that will take the form of a binder that's in the kitchen, for example. Obviously, you can't do that in the remote workplace. So how do you do it? Well, you put it on an intranet, or you put it on a OneDrive or a SharePoint, something that's accessible to the employees. Remote work place, I think things like emergency contacts become more important. Check-ins on your employees when they're working alone become important. Ergonomic checklists. I think having a very specific policy for working from home, having the employee inspect their workplace, I've seen employers require photos of the workplace. Alternatively, they'll do a video walkthrough of the workplace to inspect it for hazards, things like wires, papers piled up on the floor, ergonomic assessment, and so forth. So you're trying to, and for the most part, because this legislation hasn't caught up to the home workplace, you're trying to think about the things that you would be doing in the office and how you could apply them in the home.
So I think we're going to move to data security and confidentiality, Alex, unless I've interrupted you.
No, that's it for me on that point.
So I won't go into this in maybe quite as much detail because we are coming up on the end of our time. But one of the risks of remote employees is data security and confidentiality. I'm seeing this become more and more important with my clients, confidentiality in particular. But we've seen lots of examples of data breaches and companies being hacked and all of that. So that's an increased risk when you have an employee who's working remotely as opposed to in an office. And it's not just a matter of cybersecurity, it's having a laptop, at home, maybe leaving it open, stuff like that. So as lawyers, we have to be abundantly aware of confidentiality and privacy. And so I think we're hyper aware of all of these things, but you might be surprised, the things that employees don't know or don't think of. And so setting a clear expectation at the beginning can be really helpful. We talked earlier about, what does working remotely mean? Does it mean working from home in a secure home office where you know where the employee is, their setup? Does it mean that an employee can bring their laptop anywhere they want as long as they're working and log on to any Wi-Fi that they want? Having clear policies and expectations in the workplace around data security for employees in general, but also those working from home is really helpful. So for example, maybe you need a policy that lets employees know that they can't use a company laptop, at a public cafe. They can't open their laptop at the airport where the airport Wi-Fi is accessible to everybody. Having clear processes in place for that. Privacy, depending on the nature of your business, maybe you don't want employees, sitting in a cafe taking a phone call where a bunch of other people can, hear the conversation that's being had. Maybe you don't want them having, Zoom or Teams meetings in a cafe where other people can see what's going on. So setting those expectations, I think, from the beginning is very helpful. And I think in part because a lot of this turns on just a lack of awareness from certain employees. And so setting the expectation, I think in that case can avoid a lot of those issues by just communicating it early on. I think a lot of those issues are inadvertent mistakes that can be avoided by having good training. And we do also recommend that every workplace basically have confidentiality agreements in place as part of onboarding. So I'm going to leave that one there because we're coming up on the last bit of our time. And I know there was a lot of interest in the pre-session questions about tax implications. So I'll hand it over to Alex for that.
Yeah, and I think, certainly unless we get cut off, happy to stick around for a bit and address some of the questions we got in advance and if there are any others that come up. But the last of our sort of key risks is the tax implications of remote work. And I just want to draw your attention specifically to new CRA guidelines. They came out in early 2024. Essentially they provide more clarity on what the place of employment is for payroll purposes. This is somewhat confusing, but you might have an employee who's governed by one set of laws for their employment rights, so workers' compensation, occupational health and safety, employment standards, but a different province could govern as their place of employment for payroll purposes. And so there is a very handy guide on the CRA's website now about determining the place of employment for payroll purposes. Largely speaking, it's the where you should be withholding tax for the employee is based on the location of the office that employee has the strongest connection to. So it's not necessarily the closest office. It's not necessarily the province that they're actually living in. It's the one that they have the strongest attachment to. So when you're dealing with fully remote employees, that can be quite difficult to parse out. But let's go with your hybrid employee. Hybrid employee, they're in the office a few days a week, or they're in the office from time to time. The fact that they're attending to that office is a pretty good sign that that location, whatever province that office is in, is their place of employment for the purposes of payroll. So use the tax rate in that province, whatever other payroll taxes might be applicable in that province for that employee. When you have the fully remote employee who never comes in person, then you have to ask this hypothetical question of which office would they attend if they had to attend an office. If that doesn't answer the question, you might look at other secondary factors, such as meetings, where they would go, where their supervisor is located, where they might pick up materials from the employer. And if that doesn't answer it, then you go back to the old system, which is where are they actually paid from? Where is issuing their T2 and taking on the cost of issuing the T2. This is, I should just note, this is for everywhere outside of Quebec. This is the CRA rules for the common law provinces. But the oddity here for remote employees is that they might be getting taxed at the wrong rate. So they might be working in BC, but because the office is here in Nova Scotia that they report to, they're getting taxed at the Nova Scotia rate, which means that they may be getting more or less depending on the difference in the tax rate, and that will only be reconciled at the end of the year. The employee can go to the CRA and get a letter of authority that they can give to their employer to change which tax rate is used for their withholdings, but that's on the employee to do. So that brings us to the end of our formal session and slides. I know that we had a lot of questions, and I think we've answered a lot of them throughout. But if there are any that people want to put into the Q&A, or if there's any that Abigail we want to address that we've got in advance, I'm happy to do so. If not, if you have to drop off, I just want to thank you very much for your attention today. Very much appreciated that you could join us.
I'm not seeing any, I don't think, and I think we've covered most of the questions, or at least tried to cover most of the questions we got in advance. So I think that will wrap up. Okay, very good. There's a poll that's been posted. If you wouldn't mind answering just how you found the session today. And if you do have other questions that we weren't able to answer during the course of our presentation, please feel free to reach out. Great. Thanks, everyone. Enjoy the rest of your day.